Good morning, good afternoon, good evening to all the participants in this topic, blockchain-based dispute settlement mechanism. Now, thank you for the organizers, HCCH and CODIFI, inviting me to talk about this rather hot topic, at least in Hong Kong, in China, and in the Asia region, and very likely globally as well. Well, my name is Ronald. I'm a partner at Baker McKenzie, Hong Kong. I'm an arbitrator, a mediator, a sports arbitrator as well. I have a fellowship, fellow of the Chartered Institute of Arbitrators, fellow of the Hong Kong Institute of Arbitrators, and accredited mediators. So I'm qualified in Hong Kong, England and Wales, Australia, and the Greater Bay Area. So you can see all my citations in this page. And if you need to look further, you just type Ronald and log into Baker McKenzie to know about me further. Now, without further ado, let's talk about this blockchain-based dispute settlement mechanism. Some of you may know in this past weekend, it is what we call the Mid-Autumn Festival in Hong Kong and in China as well. Now, Mid-Autumn obviously is to celebrate the Mid-Autumn Festival. It is a tradition that the family will gather around to have dinner. Now, during one of those family gatherings, one of my cousins, he is actually the founder of one of the first digital bank in Hong Kong, WeLab Bank. Okay, Mr. Simon Long. Now, I actually raised this with him during this family dinner. And his comment was, the digital world is a wild, wild west. Now, the question is, should there be a sheriff or can there be a sheriff? Obviously, the answer whether there should be a sheriff is a must. There must be a sheriff. Now, the difficult question is, can there be a sheriff? Now, obviously, we cannot have a foolproof system of law, okay, to govern this digital world disputes. But hopefully, by suggesting some comments, at least what Hong Kong and mainland China has done, hopefully it will provide some sort of incentives, okay, or comments, so that CODIFI can share it amongst themselves and learn a bit more what Hong Kong and China has done in that respect. Now, today we're going to talk about are digital assets personal properties, the common digital assets disputes, which there are a couple in Hong Kong right now. How settling digital assets disputes through arbitration, because in Hong Kong and in China, many of those disputes are settled by way of arbitration. Now, what Hong Kong has done is their licensing regime, not so much on the virtual assets, but through other means as well. And of course, the legal regime for NFT, which everyone is talking about in Hong Kong now, NFT, and probably in the world, trading NFT, etc., bearing in mind that Hong Kong is the second largest art trading center in the world. So NFT becomes one of the hot topics in Hong Kong, and there are many NFTs trading at the moment in Hong Kong. And of course, to wrap it up, the legal landscape in China as well. I was fortunate enough, when I come to talk to that point, be involved in the SCIA, the South China International Arbitration Center case, which was, I believe, was the first digital currency arbitration in China and possibly in Hong Kong as well. Okay, let's start with digital assets personal properties. Obviously, what are digital assets? Okay, or in Hong Kong we sometimes call the virtual assets, because a lot of the law are based on whether this type of virtual assets, as we call them assets, is actually assets under the laws of Hong Kong. Now, Hong Kong, it's a common law jurisdiction, one and the only common law jurisdiction within China. Okay, the rest is running on civil law system. So a lot of the concepts, some of the participants may be familiar with. Now let's start with the Hong Kong side first, on the left-hand side. Now, because it's such a new topic, there's no Hong Kong case addressing this issue explicitly. Now, obviously, for those who knows about common law system, we work on a case authority system. Now, but there are two cases which indirectly suggest that this cryptocurrencies, dealing with cryptocurrencies, are in fact assets. Because they are dealing with a Mariva injunction. The first one is a Hong Kong court granted a proprietary and Mariva injunction. This is the Nico Constantinian Antonius Samaras case. The other one also dealing with an injunction is the Yan Yu Ying versus Leung Wing Hei case. Now, obviously, I'll go further into the background of the case. But obviously, for those who knows about injunction, to grant an injunction and you are preventing someone to do something, preventing someone from disposing, for example, of certain assets. Okay. Now, by virtue of the fact that there's an injunction, and the court has not stated that the cryptocurrency is regarded as a property, but at least by granting such injunction, it appears to the court that, well, the cryptocurrency can be regarded as an injunction. Now, looking on at the China side, the rest of the jurisdiction, Hong Kong obviously it is part of China, but running on the common law system. The rest is actually on the civil law system. Now, cryptocurrency has been recognized as a property in China. Now, I talk about the SCIA, okay, we call it the Shenzhen Arbitration and Commission, or as we call it, the South China International Arbitration Center. Okay, I just got the SCIA, or the SAC. Now, as of September 2021, all cryptocurrencies are illegal in China. Okay, now, there were some suggestions before 2021 that cryptocurrencies may be regarded as an asset or regarded as legal. And no one came out and said it was legal before 2021. But after that case, the Chinese government came out and said that, well, cryptocurrency is illegal in China. So whatever arbitration awards are there was being set aside. Obviously, I'll come to discuss that further later on in the presentation. Now, let's talk about the possible disputes. And as I mentioned before, you saw the two cases, the two court cases currently or previously in court seeking injunction. Now, as far as I know, because I sit as a council member of the Hong Kong International Arbitration Center, the HKIAC, I know that there are a couple of cases by way of arbitration dealing with disputes arising from cryptocurrencies and virtual assets. Personally, I have also assisted and drafted contracts in relation to sale and purchase of cryptocurrencies 2 or 3 years ago, despite the fact that I am a dispute resolution lawyer. Now, obviously, there are the fraud, the ownership possessions, smart contracts, agency relationships, remedies, injunction, and fortifications. A lot of people are very interested in the injunction. I mentioned previously in the two cases, it was dealing with injunction. And of course, remedies is what everyone is looking for. Smart contracts, it's one of the popular topics of discussion in Hong Kong at the moment, but it is still in an early stage. So smart contracts, I'm certain that there will be disputes, but possibly in around 2 or 3 years' time. Now, let's look at the recent case, Yan Yu Ying. Okay, the defendant helped the plaintiff to initialize what we call the Teresa device, a cold war, so that the plaintiff can transfer the bitcoins to the cold wallet. Now, the cold wallet provided was not the new one, and the defendant has what the judge says, the recovery seat. Now, they use the recovery seat to regain access, okay, to the bitcoins and transfer the bitcoins to the defendant's own wallet. So someone is buying it, the defendant, and transfer it, but defendant retain control of the cold wallet and transfer some of them back to the defendant's own wallet. Now, obviously, the plaintiffs was alleging theft. Okay, the theft was committed by the defendant. Now, in the defendant's case, the Bitcoin was swapped with what they call the TPC, okay, another type of cryptocurrency, TechPay coins, as I remember the TPC is called, under a swap agreement. Now, two things came up because a theft, there must be according to the theft ordinance, okay, in Hong Kong, and the crimes ordinance, theft of something, it must be a property, but property can be a physical property, but it can also be a virtual property as well, like intellectual property rights, okay, but it has never talked about virtual assets, okay, or virtual properties. Now, as I mentioned before, an injunction was granted, okay, by granting that injunction, okay, the court, if I can add words to the High Court of Hong Kong, is that they are indirectly suggesting that the cryptocurrency is a property, because you can only injunct by law a property. Okay, now to prove that this is a new area of the law in Hong Kong. In Hong Kong, when you grant an injunction, there is no automatic requirements of what we call cross-undertaking, cross-securities. Okay, but obviously here, obviously the Hong Kong courts, they do have discretion to grant cross-securities. But in my experience, not unless in a really particular or peculiar case where the facts are not overly certain. Okay, only in such situation where the court may grant cross-security. It has been done before, but not often. Now, because of time constraint, I won't go through the reasoning why the court granted cross-undertakings or cross-security in this matter. But it is sufficient for the purpose of this talk that the court in this case actually granted cross-security, okay, for the claims, because for an injunction, it is what we call an interim measures where the principal case will continue, the plaintiff and the defendant's main claim, but in the meantime, the plaintiff obtained an injunction forbidding thee to do something. Okay, so in this situation, then the probably because of the nature of the virtual assets, the court granted cross-security in this matter. Now, let's look at the nickel case. Now, the plaintiff and the defendant, we're talking about the plaintiff and the defendant not as a buyer and seller, but basically as a principal and agent. Plaintiff, by number of transactions, passed 1,000 bitcoins to the defendant. The defendant charges 3% commissions. The defendant provided the login details and the security token of the defendant's bank account in Hong Kong, so that the plaintiff can get access to the defendant's bank account. Now, the defendants obviously, once the plaintiff got access to the defendant's bank account, the plaintiffs can transfer money to the plaintiff's bank account in Germany. Now, the defendants and is the agent, okay, or from the chart appears to be the agent. Okay, this is one of the issues raised in court. Now, the defendant, allegedly being the agent of the plaintiff, proceeded with the sale of the coins, the bitcoins, to Gatecoin Limited and TDA. Now, you may see the two crosses, okay, on this chart. The reason is that whilst the defendant deposited money to his bank account, okay, to the defendant's bank account, and the plaintiff has login details, but the plaintiff only obtained a couple of sales proceeds from the defendant's bank account. The remaining proceeds were not remitted into the defendant's bank account, or the defendants changed login details and the security tokens, so that the plaintiff could not get his or her hands into the defendant's bank account, thereby remitting money to the plaintiff's bank account in Germany. So this is the factual situation. Now the plaintiff, to show it is a 1219 case, to show the nature of virtual assets, unlike any physical assets where you can show ownership by giving some sort of documents. In a property, you can do a property search in a real property. You can do a real property search, okay, do a land search, as we call it in Hong Kong. And even in as simple as a car, okay, as a motor vehicle, well, you can show the transaction records, okay. But in virtual assets, it is difficult, okay, at least according to the plaintiff, to show that the Bitcoins actually belongs to the plaintiff. Now, therefore, the plaintiffs make an application to court and say that, well, defendant, you have to show that the coins that you have, you remember the plaintiff passed 1,000 Bitcoins to the defendant. The defendant must show that, hey, the Bitcoins that the defendant is holding belongs to the plaintiff. Now, the defendant's argument, okay, was that no, that's not the rule. Plaintiff should have the burden of proof. But then the defendant came out and said, well, it is not that difficult to show that the coins did belong to the plaintiff. Now, and these are some of the public records of transactions, like the seller's public keys, the buyer's public keys, the transaction hash, the time, volume, and quantity of the Bitcoins transacted. Now, I actually read that case over the weekend. It is, and as I started, I was involved in the sale and purchase of Bitcoins a couple of years ago, one of the first transactions in Hong Kong. Well, that will be another topic of discussions maybe in the future. But according to my experience, when you have these records, it is sufficient to show that the coins did belong to the plaintiff. Now, the court, although the reasoning, okay, what I want to show in this case is that the court granted an injunction and that indirectly stated that the Bitcoins is regarded as a property. Now, but these are also supporting factors, as I like to call them, to show that the Bitcoins is regarded as properties. Now, principal agency relationships was established. The plaintiff transferred the Bitcoins to these nominated Bitcoin wallet and entrusted him to sell the same on his behalf as his sales agent. Now, all these concepts are not Bitcoin related or virtual assets related. All these are the good old principles which has been operating in the world for over 100 years. But all these principles, okay, applied previously to properties as we know it, physical properties, okay. But this is one of the case where this HO, principal agency relationships, are applying to virtual assets. Now, a question, okay, by applying these principles, is the court agreeing to the fact that Bitcoin is in fact a property? very much like real properties, very much like the properties that me and you who has grown accustomed to in life. And of course, the breach of fiduciary duty by D, so that D was not entitled to any commissions. And of course, the remedies, being a dispute resolution lawyers, many of our clients are not so much interested in the legal principles. I would say that only lawyers are interested in the legal principles. Many of them are interested in the remedies. So the declaration that the Bitcoin transferred to the defendant and the proceeds were sale, and proceeds of sale were held by the defendant on trust. So the court ordered the defendant to transfer the Bitcoins and pay the amount due to the plaintiff, etc. Okay, so now these are one of the 2019 case, one of the 2022 case. These two cases, what are the takeaways? Cryptocurrency constitutes property. Okay, or at least is the judgment seems to believe so, applying the HO principles as if cryptocurrencies is like any type of properties. Is the importance of keeping comprehensive records, okay, including public records, and of course familiar with the legal principles of trust and injunctions, etc. Now, I would add here is that I imagine that in future disputes, cryptocurrency will be regarded as a property, okay, like any other properties. The difficulties which are coming later on is how to categorize. I wouldn't call it cryptocurrencies, but virtual assets. What falls within the definition of properties? Obviously, as I mentioned before, the two cases as the courts considered cryptocurrencies, not virtual assets. You've got to understand that, okay? Because the two cases are dealing with cryptocurrencies. Obviously, cryptocurrencies appears to be properties. But how about NFTs? How about in the future, there may be some other form of virtual assets? Okay, so we will leave that question later on. Now, settling disputes in Hong Kong, many of the cases are by way of arbitrations. Now, it just happens by coincidence that because it's such a new topic, okay, and the injunction happens to be in the High Court of Hong Kong. But as I mentioned previously, the HCCH, the Hong Kong International Arbitration Center, they do have a couple of cases on disputes arising from the sale and purchase of cryptocurrencies. NFTs, we'll talk about it later, but so far it's on cryptocurrencies. Now, just to look at the statistics, okay, in year 2022, the number of cases 279. There, of course, total number of cases 279. Number of cases administered and 205. Now, so as compared to 2021. Okay, it's already a drastic increase. Obviously, the difference are not solely in relation to cryptocurrency disputes, all sorts of commercial disputes, but many of the cryptocurrency disputes, okay, choose Hong Kong as a place of arbitration. Okay, obviously many of this arbitration will be done or have been done or is currently being done by way of electronic means. Okay, you can have a look at the statistics. The statistics, they don't lie. Okay, this is the statistics we have from the HCCH, hot off the press, so to speak, just got it yesterday. Now, I mentioned that we're talking about virtual assets. Okay, so I'm going to throw in this one here. In that, we're talking virtual. Many people I talk to are saying there were settlement disputes. Okay, we're talking about virtual assets, such state of the art. Okay, dispute, state of the art properties. Okay, one of the new inventions. Do we have to go to court? Do we have to do physical arbitrations? Obviously, no. Okay, in Hong Kong, in 2018, there is something called EBRAM being set up. Okay, electronic business related arbitration mediation. Now, as far as I know, it's specializing only on online disputes. And obviously, they have received cases. It's 2018, and quite new setup as compared to HCCH, but online dispute resolution is gaining traction. As far as I know, they have received inquiries regarding putting online dispute resolution clauses in virtual assets agreement as well. So EBRAM is something to look out for on the online dispute resolution scene. Now, let's talk about the licensing. We will talk about the courts have recognized cryptocurrency, okay, as properties, or at least indirectly recognize them as cryptocurrencies, as properties. I think the difficulties comes in not so much as in whether it is regarded as property, but more as in how can they regulate, okay, such sale and purchase. Now, when things happen, there's a dispute on the contracts. It is easy. You go to courts, you go to arbitration, be it online or be it physical. But the difficulty is, should there be a sheriff, which I mentioned in my first slides? Should there be a sheriff? Okay. Now, everyone says that there should be a sheriff. Okay, I don't think anyone will say that, oh, there should not be a sheriff to look over the shoulders of the wild, wild west, okay, as my cousin puts it. Now, the question is, can there be a sheriff? Now, let's look at some of the efforts made in trying to have a sheriff in this wild, wild west digital world. Now, the current regime, largely unregulated. That's why my cousin, who's the founder, as I mentioned, of WeLab Bank, was saying that unregulated. It is why it is called the wild, wild west. And of course, voluntary opt-in licensing regime in 2019, in November 2019. Okay, and only one virtual assets trading platform has obtained the SFC's license. Obviously, I'm not saying that everyone is a crook, or obviously I'm in the wild, wild west. I don't want to obtain a license. Okay, but like any regime, like any new trading platform, okay. Rather than voluntary opt-in, okay, the government may need to have a compulsory opt-in regime, okay, for virtual assets. Especially, once again, using my cousin's words, you are in the wild, wild west, okay. So, should there be a compulsory opt-in? Now, of course, there's the consultation in 2021. It's only a consultation, it's not yet law. Okay, they need to impose full range of anti-money laundering, okay, obligations on the virtual asset service provider, etc. Now, obviously, with any new implementation or compulsory opt-in, there will be a split views, okay. But whether there should be a compulsory opt-in licensing regime, it is basically, I would say, one of the considerations which CODIFI may need to consider. Okay, as mentioned in this week's program, we are all here to talk about what each of our jurisdictions are thinking. Okay, Hong Kong is having a consultation period on whether this VASP, a licensing regime on the anti-money laundering on virtual assets trading platform, should be licensed, should be regulated. Okay, I think if I have to place my bet on this, I would say that the likelihood of a compulsory license is very likely. Now, of course, apart from the licensing system, when I did my transaction, assisting a client on the transaction of the sale and purchase of Bitcoins. One of the main thing that that I have encountered was actually not whether it is a property, whether they are licensed. It's in fact the anti-money laundering mechanism is in Hong Kong. I would say that Hong Kong has the most stringent anti-money laundering system or the laws in Hong Kong. So when I did the transactions, I think many people will have the idea of saying that, oh, virtual assets, cryptocurrencies, it must be related to anti-money laundering. Whether it is anti-money laundering, a money laundering mechanism or not, is another thing. Okay, but one of the main things that I faced, obviously there will be money going through the banks. No one is going to give you a suitcases or a couple of suitcases of money to buy the cryptocurrencies. Now, so the Anti-Money Laundering and the Counter-Terrorist Financing Amendment Bill 2022 is being consulted, okay, by the public, or more correctly, by those people trading in virtual assets. Now, you can take a look at it. What's the definition of virtual assets? Generally refers to digital representation of value that can be transferred, stored, traded electronically, etc. Now, it is still in a bill format, so nothing solid has been done. The question is, with the new NFT, is it regarded as virtual assets? Now, so you can read up on my slides later on. Now, the licensing requirements and conditions, going back to licensing, only companies incorporated and registered in Hong Kong, we need to apply a license. That's the thinking behind it. License VA exchanges, and that's a fit and proper person test, like in any companies or entities operating in the financial industries, obviously adequate financial resources. Should there be money, like in insurance companies, have sufficient reserve within the company, just in case it goes bankrupt, etc. Now, professional investors, it is something interesting. Professional investors is not listed as a sample conditions in the bill. Now, what is professional investors? For those involved in the Lehman Brothers, at least in Hong Kong, the professional investors, when there was a payout, so to speak, when a lot of the investors are suing banks and not informing them of the danger of buying such a Lehman Brothers bonds, etc. The professional investors at the initial stage was cast out of that category, because the reasoning was that, well, you are professional investors, you should know the complexity and the risk involved in investing in those Lehman Brothers bonds. Okay, now there was obviously an outcry as to what is regarded as investors. Okay, so this whether you invest $1 billion will automatically categorize you as a professional investor, etc. Now, so these are all pretty new, so to speak. Now, so what are the implications? Peer-to-peer exchanges are not subject to licensing regime. I probably missed that part because the licensing does not apply to trader to trader. Okay, sell and purchase of Bitcoins. Now, it's a bit baffling why it does not apply to trader and trader sell and purchase, but obviously it is still in consultation period. Uncertainty of professional investors, similar to the Lehman Brothers period, and of course uncertainty as to whether the NFT, okay, is applicable in this regime. Now, for NFT, it is still in the embryo stage. Okay, now many people, I heard from my friends are involved in buying and selling of NFTs. Every now and again, I hear the news that someone make millions of dollars in trading NFTs, etc. Obviously, the regulators, the SFC, the HKMA, monetary authorities, have no such records because it is still extremely new, okay, at this stage. Now, that doesn't mean the regulators have not looked into this situation. Now, they have not even gone into the stage of consultation, okay, but they have just issued statements, okay, which what a regulator should do, the SFC, okay, in saying that, well, when you go and buy and sell the NFTs, be aware of certain things, okay, like in any financial products. Now, unless an NFT are exposed to heightened risk, okay, this is just any financial products. Where an NFT is a genuine digital representation of a collectible, it falls outside the scope of the SFC regulatory remit. Okay, obviously many people are buying NFTs for private enjoyment, okay, but when it comes to SFC, actually it made this comment, when it comes to a collective investment scheme, the SFC will have the jurisdiction to look over this. Now, obviously it is true because you're no longer talking about a person buying a NFT for private enjoyment. You may have 100 or a good couple of person buying an NFT for investment purpose. So this falls within the this may fall within the collective investment scheme. As I said, which is regulated by the SFC. No one, and this is still in the embryo stage. So it is not in a consultation or not even in a law format or bill format. It is just a warning statement, as I would like to call it, to tell the investors of the risk involved. So, potential risk of disputes, poor and non-existing contracts. I'm sure that the participants here and some wise lawyers will soon come up with some sort of contracts or even smart contracts on NFTs, if not already smart contracts existed in the world. Unclear ownerships, okay, and trademark and copyright risks as well. Now, a quick rundown of the legal landscape in China. Now, it started in 2013, where what is Bitcoins? Okay, and no one has actually came out before 2021 and say that Bitcoin is legal. Okay, in China. In fact, in 2017, refrained all organizations and individuals from raising funds through ICO. Okay, so that was the first stint of the thinking of the Chinese government, and indicating that it may not be illegal, but not saying that trading of Bitcoin is illegal, but ICO is illegal. Now, when it comes to the 2021, the SCIA, the Shenzhen Arbitration Commission, or the South China International Arbitration Center case, I remembered because I was invited to comment on that award. Okay. Now, it comes out that virtual currency do not have the same legal status as legal currencies. Now, that's different from whether it is regarded as a property. Okay, it's just saying that it is not the same as legal currencies. Virtual currencies related business activities are illegal financial activities and shall be prohibited. Now, that's from the government. Okay, the government came out and say that all these activities, okay, are illegal. Now, so on the one hand, you have the arbitral award. Okay, on the other hand, you have the government, and subsequently, I remember they were subsequently coming up and say that it is illegal. Now, so eventually, if the arbitration award was set aside due to public policy reasons. Now, of course, in the latest run in 2022, many industrial associations, not the government industrial associations, jointly issued a proposal on preventing NFT-related financial risk. Now, we are no longer talking about our cryptocurrencies, etc. We are talking about NFT-related financial risk. Okay, and these are not government officials; these are industrial associations. Now, it is still a big question mark as to whether this is regarded as any indication of the thinking of the government officials, but the industrial associations came out to say that there are risks in NFT tradings. It is yet to see the development in China on this aspect. Okay. Now, as I mentioned before, the SCIA, the Shenzhen Intermediate People Court, okay, the arbitration award be set aside due to public interest. As I mentioned before, there was the arbitration award, and then the government came out and say that the officials came out and say that these type of transactions are illegal, so the award was set aside in view of public interest. Now, of course, Hangzhou being the center, okay, of ITs in China, adopted smart contracts in the judicial reform in 2019. Okay, this obviously has been somewhat stalled because of the 2021 case, where the government came out, where the court set aside the arbitral awards because of the government policy saying that Bitcoin trading is illegal. But of course, in here, we're not talking about Bitcoin's Hangzhou, we're talking about blockchain judicial reform. Now, the first civil trial using smart contracting technology for filing was conducted in 2019. I yet have to look further into this because I understand that Hangzhou in 2019 have this initiative. I was invited to Hangzhou to look at the development, but because of personal reasons, I did not go there, but I've been kept informed of this development. Okay, it is yet to see how this pans out, the smart contracting in blockchain judicial platform. I understand that as it is still operating in China at the moment. Okay, obviously, because of time constraint, you can read up on the civil trial, the smart contracting technology. So that is the end of my presentation. I hope the presentation have given the participants some thoughts on the development of a blockchain dispute settlement mechanism in the Hong Kong side and in the China side as well. Now, if you have any questions, please feel free to pass it on to the organizers, and they will pass it on to me, and I will try to answer the questions. Now, finally, I must thank one of our associates, Anthea Yu, who has so painstakingly complied the first draft of the slides, and of course finalized the slides for me in this presentation. So thank you, Anthea, for your assistance in this. So thank you, participants. Thank you, organizers. Good morning, good evening, good afternoon, and good evening. Thank you.